And you are Kennedy Polidor.
Yes, sir.
Well, it looks like you have two cases here. One of them is going to be dismissed, right?
Yes.
That's a good thing. That's always good. 783, the evading arrest or detention with a previous conviction. Well, that's a good thing. You okay there, kid?
Yes.
Because you were looking at a state jail felony that was going to be punished as though it were a third-degree felony. You were looking at up to 10 years in prison on that one. Here we have a second-degree felony, though. That's not any better. And illegal possession of controlled substance, cocaine, right?
Yes.
All right. 25 CR 971 and 25 CR 783 are both called the state of Texas versus Kennedy Polidor. That's you, Mr. Polidor.
Yes.
Here with Ms. Manali, your attorney and the state's attorney. Now, cause number 971 is going to be pleaded to, and the other case will be dismissed as part of this agreement. So let's take up 25 CR 971. Does the defendant waive a formal reading of this indictment and arraignment here? Can we proceed in summary?
Yes.
In summary, Mr. Polidor, this indictment handed up on August of last year states that on or about October 24th, 2024 in Jefferson County, Texas, you committed a second-degree felony of illegal delivery or transfer of a controlled substance, namely cocaine. Do you understand what you're charged with here?
Yes, sir.
This is a second-degree felony, which means if convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? Agreement's been reached further where you would be pleading guilty and sentenced to 5 years in, is that 5 or an 8?
5, Judge.
All right. If I follow this agreement of 5 years in prison, sir, you have no right of appeal of your case. And also, a corollary to that, another case, 783, will be dismissed as part of this deal. Is all of that your understanding?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty, sir?
Guilty.
I'm going to show you what's marked with State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection is submitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You understand what you're charged with? The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes, sir.
State's Exhibit 1 is part of the record for all purposes. This is a pre-sentence report waived.
Yes, Judge.
I'm going to follow this agreement then, sir. I'm going to find you have entered your guilty plea freely and voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty, and you are pleading guilty to this offense.
Yes.
Voluntarily, knowingly, intelligently, and because you are guilty.
Yes, sir.
There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of the second-degree felony. In this case, 25 CR 971, illegal delivery of a controlled substance, namely cocaine. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years.
Yeah.
I don't know how much time you have served already. You will be given credit for all time you may have served in custody in accordance with this case.
Yes, sir.
And in 25 CR 783, that is dismissed. Done. Anything else?
No, Judge.
Recess on this thing?
Judge, I believe he told me he's hired someone, but it's back.
You're Antonio Key. Laundry. Okay. In 25 CR 1671, you're charged with a third-degree felony of harassment of a public servant. Looks like A Port Arthur police officer. This
Sorry?
is what happened here. Okay, a third degree felony carries with it up to 10 years.
Sorry, Judge.
Third degree felony carries with it up to 10 years in prison and a fine up to $10,000. Do you understand what you're facing here? All right. Ms. Minaldi, is your turn. What are we doing today?
Did you hire somebody on this case? Are you gonna hire somebody on this case? Okay, I need 4 weeks, Judge, to review all.
We said 4 weeks.
I need you to wait. I need you to fill something out for me. Okay. Okay.
Get a resetting from this lady right there. Come on up. We recall 25 CR 1671, State of Texas versus Antonio Keith Landrio. As you know, you're charged with this third degree felony of harassment of a public servant. The court ordered a drug test of you. You know how you did. You've got cocaine and let's see, what else? Meth in your system. So what is this bond? Your bond is revoked. Immediate. You need to fix this mess. You're free falling. No, it's not a test. You're charged with a serious crime already. This looks like $25,000. Is that right? All right. It is doubled to $50,000. This revoked $50,000. Plus, you must have a drug patch as a condition of bond at all times, and that is the order of the court. Next time, it'll go up to $100,000, and you just throwing money down the drains. But you've got a problem here that needs to get fixed. What are we going to do right now? He's taken into custody.
Judge, he was already reset 4 weeks.
Reset. Oh, it is done. Here, you need a copy of this later?
Yes, please.
That's the order of the court. You're in custody.